they will be having with the Norfolk New England Men's
All right, good morning, everyone. This meeting of the Escambia County Planning Board for May 6, 2025 is hereby called to order with 4 voting members present. We do have a quorum. Just a reminder to please turn off your electronic devices or just put them on silent either way. And if you could, please stand and join me in the Pledge of Allegiance.
for liberty and justice for all.
All right, thank you. Did we have proof of publication?
Yes, sir.
Did the publication meet all legal requirements?
Yes, sir.
And I'll entertain a motion to read, or to waive the reading of the legal advertisement. Do we have a motion?
Motion to waive.
Do we have a second?
Second.
All right, all those in favor, please signify by raising your right hand. All those opposed, motion carries. Rezoning meeting minutes for the previous meeting dated February 4th, 2025 has been provided to the board. Were there any additions, deletions, or corrections? If not, I'll entertain a motion to accept the rezoning meeting minutes into evidence.
Motion to accept.
Second.
Got a motion and a second. All those in favor, please signify by raising your right hand. Motion carries. The rezoning hearing package for May 6, 2025 with findings of fact has been provided to the board members. I'll entertain a motion to accept the rezoning hearing package with findings of fact and the legal advertisement into evidence. Do I have a motion?
Motion to approve.
Motion. Do we have a second?
Second.
We got a second. All those in favor, please signify by raising your right hand. All right. Will the court reporter please swear in members of the staff?
Raise your right hand. You solemnly swear or affirm testimony about to give in this case will be the truth, the whole truth, and nothing but the truth. I do.
All right, and the board has previously qualified staff to offer expert testimony in the area of land use and planning. Does anyone have questions regarding their qualifications and ability to offer expert testimony? All right. At this hearing, the planning board is acting under its authority to hear and make recommendations to the Board of County Commissioners, the BCC, on rezoning applications. These hearings are quasi-judicial in nature, and these hearings are like evidentiary hearings in a court of law, however, less formal. All testimony will be given under oath, and anyone testifying before the planning board may be subject to cross-examination. All documents and exhibits that the planning board considers will be entered into evidence and made part of the record. Opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. Before making a decision, the planning board will consider the relevant testimony, exhibits entered into evidence, and the applicable law. Each individual who wishes to address the planning board must complete a speaker request form and submit to the planning board clerk. Those forms are on the table in the back of the boardroom. You will not be allowed to speak until we receive a completed form, and please note that only those individuals who are present and give testimony today on the record will be able to speak at the subsequent Board of County Commission meeting. No new evidence can be presented at that time at the Board of County Commission meeting, so anything that you would like to enter into evidence today as you speak, please say it today so that you can then say it to the Board of County Commissioners at their meeting. The planning board will provide a recommendation for each rezoning request to the BCC, which will review testimony, documents, and exhibits, consider the closing arguments, and make a final decision. All decisions by the BCC are final. Anyone who wishes to seek judicial review of the decision of the BCC must do so in a court of competent jurisdiction within 30 days of the date the BCC approves or rejects the recommended order of the planning board. All written or oral communication outside of this hearing with members of the planning board regarding matters under consideration today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in BCC Resolution number 96-13. And as each case is heard, I will ask that any board member who has been involved in any ex parte communication to please disclose it and describe the communication. as required by Section 2-7.2 of the Escambia County Land Development Code, the Planning Board's recommendation to the BCC shall include consideration of the following approval conditions. So this is what we base our decision off of, are these criteria. The applicant has the burden of presenting competent substantial evidence to the reviewing board establishing that the requested zoning district would contribute to or result in a logical and orderly development pattern. The appropriate surrounding area within which uses and conditions must be considered may vary with those uses and conditions and is not necessarily the same area required for the mailed out notifications. A logical and orderly pattern shall require demonstration of each of the following conditions. A, consistent with the comprehensive plan. The proposed zoning is consistent with the future land use or FLU category as prescribed in LDC Chapter 3 and with all other goals, objectives, and policies of the comprehensive plan. If the rezoning is required to properly enact a proposed FLU map amendment transmitted for state agency review, the proposed zoning is consistent with the proposed FLU and conditional to its adoption. B, consistent with zoning district provisions, the proposed zoning is consistent with the purpose and intent and with any other zoning establishment provisions prescribed by the proposed district in Chapter 3. C, compatible with surroundings. All of the permitted uses of the proposed zoning, not just those anticipated by the rezoning applicant, are compatible as defined in Chapter 6 with the surrounding uses. The uses of any surrounding undeveloped land shall be considered the permitted uses of the applicable district. Compatibility is not considered with potential conditional uses or any non-conforming or unapproved uses. Also, in establishing the compatibility of a residential use, there is no additional burden to demonstrate the compatibility of specific residents or activities protected by fair housing laws. D, appropriate if spot zoning, where the proposed zoning would establish or reinforce a condition of spot zoning as defined in Chapter 6. The isolated district would nevertheless be transitional in character between the adjoining districts, or the differences with those districts would be minor or sufficiently limited. The extent of these mitigating characteristics or conditions demonstrates an appropriate site-specific balancing of interest between the isolated districts and the adjoining lands. E, appropriate with changed or changing conditions. If the land uses or development conditions within the area surrounding the property of the rezoning have changed, the changes are to such a degree in character that it is in the public interest to allow new uses, densities, or intensities in the area through rezoning, and the permitted uses of the proposed district are appropriate and not premature for the area or likely to create or contribute to sprawl. So at the beginning of each case, as long as there are no objections from the applicant, we'll allow staff to present the location and zoning maps of the photos of the property. Next, we'll hear from the applicant and the witnesses that they may have. We'll hear from the staff and any witnesses they may have. And then after that, we'll hear from members of the public who have filled out one of the speaker request forms there in the back of the room. There is one case to be heard today. The rezoning application for consideration is case number Z 2024-03, which requests rezoning of off Highway 297 and off Highway 297A from LDR low density residential district 4 dwelling units per acre to MDR medium density residential district 10 dwelling units per acre as requested by Meredith Bush, agent, Serena and Hoke LLC, the owner. Members of the board, have there been any ex parte communication between you and the applicant, of the applicant's agents, attorneys, or witnesses, with fellow planning board members or anyone from the general public prior to this hearing? Have you visited the subject property? And please also disclose if you are a relative or business associate of the applicant or the applicant's agent. Mr. Adams, we'll start with you.
No to all.
No to all.
No to all?
No to all. No to all.
Okay. Staff, was notice of the hearing sent to all interested parties?
Yes, sir.
Was notice of the hearing posted on the subject property?
Yes, sir.
Okay. Meredith, if you're good with it, we'll have staff present the photos.
Mr. Chairman?
Yes.
I was going to defer to the applicant on this. This case is a bit complicated how we ended up back here. I'm going to go ahead and let her handle that.
Okay.
Good morning, gentlemen. So, yeah, this case has been before you once, been to the planning, been to the Board of County Commissioners, been up to Circuit Court, back to the Board of County Commissioners, back here again today. At this time, we're gonna withdraw the application, and, not move forward with the rezoning to MDR. So we're gonna stick with the LDR.
Okay. All right. Well, thank you very much. All right. So that was our only case today. So if you did come for that, that's that. They pulled their application. So if we have nothing further on this agenda, I will go ahead and adjourn the rezoning meeting, and we will start our regular planning board meeting now. So. All right, thank you guys for coming down today. I know you didn't get to speak, but maybe you got the outcome you were hoping to get. If you could just please exit the room there in the back if you're not planning on staying for this next meeting. The meeting of the Escambia County Planning Board for May 6th is hereby called to order with 5 members present, 4 of which are voting members. We do have a quorum. Do we have proof of publication?
Yes, sir.
Did the publication meet all legal requirements?
Yes, sir.
I'll entertain a motion to waive the reading of the legal advertisement.
Motion to waive.
We got a motion. Do we have a second?
Second.
All those in favor, please signify by raising your right hand. Motion passes. Planning board meeting minutes for April 8th, 2025 have been provided to the board members. I'll entertain a motion to accept the planning board meeting minutes into evidence. Do we have a motion?
Motion.
Got a motion. Do we have a second?
Second.
Second. All right. All those in favor, please signify by raising your right hand. All those opposed, motion carries. The planning board hearing package for May 6th has been provided to the board members. I'll entertain a motion to accept the planning board hearing package and legal advertisement into evidence. Do we have a motion?
Motion to accept.
Motion to accept. Do we have a second?
Second.
Second. All those in favor, please signify by raising your right hand. All those opposed. All right, motion carries. We do have a couple of public hearings today, and our first one is SSA-2025-02. A small scale amendment application for consideration is case number SSA 2025-02, which requests a future land use change on the 3900 block Kelly Ave and 3920 Kelly Ave A and B from commercial to MUU or mixed use urban as requested by Allison Aruda, the owner. Staff was notice of the hearing sent to all interested parties.
Yes, sir.
Was notice of the hearing posted on subject property.
Yes, sir.
Let's see here, and I'm assuming you are the applicant. If you would just state your full name and address for the record for me.
My name is Allison Aruda. The address on record that we're talking about is 3920 Kelly Avenue, Pensacola 30205, sorry.
Okay.
And my current address is 2769 Elmhurst Circle in Fairfield, California.
Okay. And did you receive a copy of the packet with staff's findings or their analysis?
Yes, I did.
Okay. And would you like staff to make their presentation first, or would you like to go ahead and go?
Go ahead and make yours first.
Okay. So staff will have you go, and then you can take a seat, and we'll get you back up here
Okay.
at that point.
Okay. Good morning. Allison Lindsay, Urban Planner Development Services. This is the location map showing the site on Kelly Avenue. This is the zoning map showing the 2 parcels as HCLI. This is the existing future land use showing the current commercial for both parcels. And this is the proposed future land use showing the requested mixed-use urban. And this is the CRA map. It's in the Palafox overlay. And this is the aerial photo of the sites. This is the public hearing sign that was posted on site. And this was our second hearing sign that was posted on this other property next to it. This is looking onto the site from Kelly Avenue, looking north along Kelly Avenue, looking across Kelly Avenue toward Norris Avenue, looking across Kelly from the site, looking southeast along Kelly, looking south along Kelly, looking south on Kelly. And that's all the maps and photography.
All right. Do you want to go ahead and go through your staff analysis, and
Okay.
then we'll have the applicant come up?
Okay.
Okay.
So this is a small-scale map amendment requesting to change the future land use from its current commercial to mixed-use urban. This is 2 parcels that are totaling approximately 0.68 plus or minus acres. And it's surrounding by parcels that are HCLI and HDMU. And the parcel is within the Palafox redevelopment area. So for small-scale map amendments, the state has 3 requirements that it must meet to be a small scale. And this is under the 50 acres, and it is not in an area of critical concern, and it does not involve a text change to the maps. So with this project, the conversion of mixed-use urban, it will allow for residential uses, whereas the commercial was only allowing commercial development. And the applicant stated that they wanted to build a single-family home. The mixed-use urban future land use, it is suitable for residential and commercial. In the areas of the commercial, it does support residential, non-residential development, and the change to the mixed-use urban will not change the area characteristics while allowing for residential development. There are majority of the parcels along that road are residential with a couple of vacant lots, and then 1 or 2 commercial developments. For the solid waste and potable water, Emerald Coast Utilities will provide the potable water and the solid waste service. So for transportation and mobility, the Traffic and Transportation Department provided a comment letter for the file stating that they have no concerns regarding the proposed small-scale map amendment. For protected resources for wellheads, the subject parcel is not within a wellhead protection area based on the Escambia County GIS mapping. And for historically significant sites, 1 parcel has an existing structure on the site and the other is currently vacant. The parcels have not been identified as having any historic or archaeological structures on them. For wetlands and habitats, there is no indications from our National Wetland Inventory map of any wetlands on site. If any protected trees are located for future development, they will be analyzed for compliance with all the applicable environmental regulations before the issuance of a development plan approval. And so basically that's the staff findings. This request does meet the state requirement for small scale, and if there's any questions, I can answer.
All right. Board members, do you have any questions for staff? No? All right. Ms. Ruda, if you'd like to come forward and fill us in on kind of your side of the table of this change.
Yes, I'm actually seeking to put 2 duplexes on the property. The entire street is residential. It would make no sense to put anything commercial on there, but there's a nice chunk of land. It's spacious and beautiful, and I take really good care of it, so I'd like to provide some more housing to the area.
All right. Board members, do you have any questions for the applicant? No? All right. Thank you.
All right, thank you.
If there's nothing further from the staff or the applicant, I will entertain a motion if someone has one at this time.
Motion to approve the application.
All right, we got a motion to approve. Do we have a second?
Second.
We got a second. Any discussion? All those in favor, please signify by raising your right hand. Motion carries. Congratulations. Good luck with everything. Yep. All right, we'll move on to our second small scale amendment application for consideration today is case number SSA 2025-03, which requests a future land use change on 9200 Fowler Avenue from commercial and mixed use urban or MUU to MUU mixed use urban as requested by Meredith Bush, the agent for Cloud9 Gulf Coast LLC, the owner of the property. Staff was notice of the hearing sent to all interested parties.
Yes, sir.
Was notice of the hearing posted on the subject property.
Yes, sir.
All right. And Meredith, did you receive a copy of the packet with findings of fact? Yes. All right, you did. And then staff, would you like staff to go first? Okay. We'll have staff go ahead and present those photos and make their presentation, and then we'll have Meredith come up.
Good morning, Board. My name is Caleb McCarty. I'm an AICP planner for the county. First, we'll present our maps and photography for the site. This is our location map showing the property between Fowler Avenue and Untriner south of 9 Mile. The property is split zoning. Along Fowler is HDMU, high density mixed use, and along Untriner is HCLI. The future land use is also split between mixed use urban and commercial. The request is to change the commercial future land use portion of the site and to the mixed use urban future land use designation. You see that on our proposed future land use map here. This is an aerial map showing the current configuration of the property. This is our notice of public hearing sign we placed along Fowler Avenue. This is looking onto the site from Fowler Avenue. This is looking onto as well from Fowler. This is north along Fowler. This is northwest across Fowler from the site, and also west across Fowler from the site. This is south along Fowler Avenue. We also put another public hearing sign along Untriner. So this is looking west onto the site from Untriner Avenue. This is looking north along Untriner along the sidewalk there. This is looking east across Untriner from the site. Also looking east from Untriner. This is south along Untriner Avenue, and that completes our maps and photography for this case.
Thank you. And if you'll go through your analysis this time.
Excellent. Again, this is a small scale amendment to request a future land use to change the eastern portion of a 8.85 acre parcel from commercial to mixed use urban. The parcel is zoned high density mixed use and heavy commercial light industrial, and is surrounded by parcels zoned high density mixed use and heavy commercial light industrial, HCLI. A future land use change to mixed use urban will allow for residential uses. Concerning our land development code future land use map amendment requirements for our compliance review, general conditions, we found that a conversion to mixed use urban will allow for residential uses, mixed uses, and heavy commercial light industrial uses. The change would remove the commercial future land use space restriction on the subject parcel that allows residential development only when secondary to commercial development. This future land use change would allow a maximum residential density of 25 dwelling units per acre to be obtained on the eastern portion of the property. Concerning professional practices, our analysis found that the proposed change will support the use of non-residential and residential uses, and that the amendment proposes a replacement future land use that allows the residential density of the existing HCLI zoning at 25 dwelling units per acre while remaining consistent with the surrounding property to the west. We also found for our future land use map amendment conditions that the parcel is less than 50 acres. The proposed amendment doesn't involve any text change, and the property is subject to the proposed amendment is not within a designated area of critical state concern, and therefore it meets Florida statutes for small-scale map amendments. Concerning other applicable comprehensive plan objectives and policy, we found per the housing element, the proposed future land use mixed-use urban is suitable replacement for the existing commercial and is consistent with the future land use of the surrounding mix of uses. As a result, the change will not allow more intense uses and densities than what is currently allowed for the largely commercial surrounding uses. Concerning number 2, future land use designations, we found that the future land use category in the area is commercial and mixed-use urban, supporting residential and non-residential development, and the change to a portion of the property from commercial to mixed-use urban would not change the characteristics within the mixed area while allowing for compatible residential development and would promote mixed uses and compact development in the area. For our infrastructure policy, we found the application did include documentation of the general adequacy of the potable water, wastewater, and solid waste services, and it's located along 2 local streets, Fowler and Untrainer. For concurrency management concerning potable water, sanitary sewer, and solid waste disposal, our analysis found that according to the application, ECUA, Emerald Coast Utilities Authority, will provide potable water, sanitary sewer collection and treatment, and solid waste collection and disposal for the subject parcels. Concerning our stormwater management and transportation mobility policies, we have a comment and a review from our traffic and transportation staff that they had no concerns regarding this proposed small-scale map amendment at this time. For our protected resources, we found that the subject property is not within any wellhead protection areas, according to county GIS. And concerning our historically significant sites, the property has not been identified as having any historic or archaeological structures. Per our wetlands and habitat and our forestry policies, our analysis showed that there's no condition from the available natural wetland inventory maps of any wetlands or hydric soils in the area. If any protected trees are located for future development, they will be analyzed for compliance within the applicable environmental regulations before the issuance of any development plan. That concludes our findings for this case.
All right, board members, do you have any questions for staff at this time?
No questions.
All right, Ms. Bush, if you'll come forward.
Thank you. Meredith Bush, 125 East Intendencia, Pensacola, Florida, 32502. We are in agreement with staff's findings. I'm happy to walk through our submittal, but I believe we meet all of the requested criteria. The change to mixed-use urban is compatible and consistent, and I'm happy to take any questions.
No questions.
I guess this is just slightly related, but did we had a case, a rezoning case on this, correct? And we had folks from Hawkins Street come in. Was that on the parcel that you own to the south of this strip of property?
So I'm not familiar with the rezoning.
Yeah, I believe the rezoning request included this piece and the one directly south.
Okay.
But the main concerns were the parcel that really addressed those homes.
Right.
That was the primary concern by the citizens, and which that was dropped and they didn't proceed and they left it alone.
Okay.
They withdrew it. Yes.
Okay. I know that doesn't have anything to do with this, but I just did.
Good memory, yes.
Okay. Good stuff. All right. Were there any questions for the applicant from the board? No. All right. I did not have any speakers from the public on this case. Okay. Oh, no. Roy Wilder is, okay. I gotcha. We just had a wrong number on here, so we got confused. So we'll have you come forward and, okay. So Roy, we'll have you come forward, state your name and address. Sure, if you'd like to, and just state your name and address for the record, and we'll find your piece of paper in here, and then we'll get your time started.
Cheryl Hendrickson, 600 Hawkins Road. You're right, we are here back a year after the first request, and what we complained about then was washing portalets outside the, behind our property. I noticed there were no pictures in the presentation from Hawkins Road, which is a concern to me because these are terrible neighbors. I'm not trusting what they say they want to use it for. I had to build a privacy fence to keep their heavy dump trucks from driving through my property and going through our quiet little neighborhood. They dump their landscaping trash and pallets. Instead of disposing of them properly, they dump them behind my house. There are 3 huge piles which can be seen from Fowler Avenue. There was not a picture of that either. They are not disposing of it properly, and I can tell you this because they built a fire behind my house, 30 feet behind my house. The fire went up 30 feet, and it was a very windy day on a Saturday. I had to call the fire department to have them put it out because I could have easily have burnt my house down. I think that's a viewing of what will come in the future. I am reaching out to you that you will help us preserve the character and quality of our residential neighborhood. We're a small dead-end street. We all keep our neighborhood upright, nice. We all know each other, and this has continually been a stress and frustration to us for them constantly coming back and trying to find other ways, I think, around the rules. Thank you.
Thank you.
Thank you.
All right, Mr. Wilder, we'll have you up next. Were you the only 2 that we had sign up for this? I just want to make sure.
Yes.
Okay.
Others are working. My niece
I gotcha.
lives across the street. She works.
Yes, ma'am.
And our neighbors had some things going on today and they couldn't come.
I got you.
Another neighbor was out of town. There's only like 5 or 6 of us.
All right, Mr. Wilder, we're just state your name, address for the record, and we'll get your time started.
All right, it's Roy Wilder. I live at 610 Hawkins Street. The fire that she was referring to was built directly behind my house, and there's one little piece of trees between my yard and theirs, and the wind was blowing all the embers over my yard. But last year I had the problem; they were right behind my house washing the portalets out, and I mean, I was in business when I was working. And I know how businesses, Buffalo, residential neighbors over, I built Walmarts, I know. And I see it happening now. I mean, it's like this man had this business for 3 years doing what he's doing on that property before Escambia County ever caught on. He was not using it the way it was supposed to be used. He was doing outside work all during the night. And it still goes on the other side now. But I mean, the man can't be trusted. I mean, and if he can push Escambia County around, I'm really surprised, because I mean, a business shouldn't be able to do that, and that's what I see is happening. All right, thank you.
Thank you.
Thank you, sir.
All right, board members, that was the only speakers I had for this case. Are there any questions for staff or the applicant at this time? Yes, sir.
If I may, I believe that this is a different type of use that's being proposed. That's currently, if Caleb, please correct me if I'm wrong, that's currently inside the pre-application review process.
Correct. We've had a pre-application submitted to county staff near the end of the year that essentially initiated the rezoning or the small-scale map amendment change. But the pre-application, although not reviewed by this planning board, is for a multifamily housing type of development. Yep.
So that's less. That would be. It would not be commercial. Definitely, it's going to be. They're proposing residential uses, and I do say for the citizens, if there are still some activities that are going. Reach back out to code enforcement, because it's my understanding also that code enforcement do have some concerns with this property based upon that. But what's being proposed is now, in the application, it's not for that type of operation.
Chairman, just for clarification, it's a single-family residence on this property?
that they're, what they're requesting?
The pre-application was for a multifamily.
Multifamily?
Yep.
Apartments or duplexes? or-
Yeah, I believe there's some apartment buildings with
Okay.
like clubhouse and stuff like that.
Okay.
Okay. Any further questions from the board?
I do have one thing. Are we causing any type of issue in the future with this other piece on Untrainer to the south of it? I mean, there's already kind of other ones going across that every which way. I mean, you know, for the proposed, for future land use there. If we're putting MU right next to what would have been commercial, or separating it like that. I'm just thinking out loud for the future and this board and everything like that. Are we going to see some other issue arise from doing this that's causing these blocks to kind of separate, if that makes any sense?
Certainly. So the future land use request would change to mixed use urban, and it may be somewhat isolated there to the south. You're correct. There is a mix and transition in this area. As you can see across the Untrainer there's a mobile home park and those type of things. As you get further down Untrainer, or Fowler for that matter, it turns into primarily single-family residence, get closer to 9 miles. So it would be somewhat isolated for that commercial piece there, yes.
And that's my worry, is just if, hey, a few years from now, Development Services is running into this issue at that specific piece. I mean, that's my thought process here. I'm not, I don't know if, you all have any other comments besides that for that, so.
All right.
Okay. I believe that may be included with the proposal, although that the allocated density is what this is going for the change, mixed use urban. They may be able to utilize that as parking and those type of things. They just can't have any residential dwelling units established with a commercial future land use.
Right.
Well, I'm referring to the one that's south of it that's not attached to this. I just hate when we're breaking off and causing what, just kind of just appears like an island, of red in a sea of yellow on one side of that road.
Yeah, and I honestly, I can't confirm exactly what the project is used for right now. It may be associated with what's going on the property, the existing property in red. From our research, it does have code enforcement action on it. To concur with the residents, yes, there appears to be some liens and those type of things from our code enforcement office. It would be hopeful that this future land use change would hopefully clean it up, if you will, for the property itself.
All right, board members, allow for any last questions you may have for the board or staff. If not, I'll entertain a motion for this map amendment one way or the other.
My thoughts are, if it was changing to commercial, we would potentially have more issues, right? This future land use is going to mixed use urban, so if I understand the citizens' concerns and I'm with you, but if it's going mixed use urban, that's right, Caleb?
Yes, sir.
Yeah. If anything, we're improving that, and it shouldn't be like it was. I'm not saying that's what will happen, but from our standpoint, I think that's kind of the way we have to look at it.
And if I may, and the citation, the code enforcement action does not go away. They still will have to satisfy all of those things, concerns, even when they move forward, that they still will have to satisfy, make sure, and go through our process to make sure that the commercial, the residential use still is compatible with the neighborhood, still apply for everything and all of those things. So, and I do understand the neighbor's concern, but I believe that there is an intent for this to make that lot better.
And if I may, I was unaware of any code enforcement violations, but I'm happy to reach out to county staff and get that information and reach out to the applicant owner to see if there's something that needs to be done. I do agree with what's been stated that the mixed-use urban is a lower intensity category, and you know, the concern with it being compatible with the existing residential, well, as was stated, the development intends to be residential.
Meredith, I have a question for you.
Yes.
On this, what image up here, the, one of my fellow board members, the red parcel to the south that you're asking, is that also owned by the same owners, or do you know, or is that part of
I'd
the?
have to look it up. I don't know
Okay.
off the top of my head.
Is that part of the development request?
Not, it looks like it may be, but again, we've only had a preliminary,
Okay.
you know, conceptual plan. It's kind of hard to tell. I just pulled it up.
And that preliminary conceptual plan is for apartments then?
Yes.
Okay.
Yes.
Which would be obviously residential use, and they're
correct.
changing from,
And that's
currently.
the need. That's what the need's for. Yes.
Great.
Well, if we're thinking that's in this, shouldn't we be waiting them?
It's not, it's separate owner.
I know, I looked at it, we can bring that in, but, that's my concern is just, you know, like I said, if we're letting that become you know, just an island out there, I worry for that one in the future there. I know that doesn't bear it, but I mean, yeah, I hate kind of doing that where it's going to be more burden on you all over in development services.
Yeah, and at such time, there were residential uses, say, if we get further down the road in the development review process, there are residential uses proposed on that isolated commercial. It would trigger the need for a future land use change. Obviously, I believe the applicant is aware of that. There could be some things they can utilize for parking and buffering and, you know, stormwater management at a later date, and it can be, but at such time, there would be residential units proposed on that piece. It would trigger that.
Right.
But at this time, I believe the applicant's aware of that.
Mr. Chair,
Yes,
yeah,
sir.
what's the maximum amount of residential units they could get on that piece of property?
It's 25 dwelling units an acre in mixed-use urban.
And it's just, I think the traffic light is on that Fowler Avenue, right, going out?
Yes.
Because you got Lowe's feeding into it, you got Home Depot
Correct.
There's a new, they just put that up, it's a new traffic on Fowler, so that's happening, yes.
Horace, I have a question. Do we have the power to force staff to address the code officials, like in future meetings on this?
If we're aware, we definitely can, if we're aware of code enforcement citations, if we are aware of it, many times we may not be aware of it. But if we're aware, we definitely can start working with them to find out where they are in the process with that. And we definitely can make the applicant aware of it as well, absolutely. And be glad to do that.
All right. Got nothing else. I'll still waiting on a motion to make some sort of action on this small scale amendment.
I motion to approve 2025-03.
Okay, we've got a motion for approval. Do we have a second for that?
Second.
Second, is there any discussion on the motion? All right, all those in favor, please signify by raising your right hand. All those opposed, motion carries. Thank you. We'll move on to our third item, a public hearing concerning the review of an ordinance amending Chapter 4, Article 2, floodplain management, and Chapter 6, Section 6-0.3, terms defined.
All right, good morning, Board. There's actually 4 items left on your agenda. They all are related. They're all part of our update to our flood insurance rate maps, or firms. The first 2 are public hearings because they're changes to the LDC. One is changing the LDC chapter on floodplain. The other one is changing the Santa Rosa Island Authority regulations that are also within the LDC. The last 2 items are sort of outside your purview, but we're bringing them to you as information items because they're changes to the Florida Building Code. The reason they're all tied together is that the state wants us to have unified language between the LDC and the building code when it comes to flood. So these were developed in conjunction with a contractor that's been working through the state with FEMA on this to sort of standardize our codes going forward. There are some changes with these new maps. Some folks got added to zones they weren't in. Some folks actually got taken out. But the changes were made. The previous maps were from 2006. Since that time, we've had a number of flood events, some quite memorable. And the new data was developed with updated LiDAR with shorter contours, basically 1 foot contours were used to develop that. As a reminder for everybody, when it comes to flooding, it's not just hurricanes and storm surge, it's rising water of any type. You can get a storm drain blocked, and the rising water, that's a flood. But these new maps, we have to take them to the BCC for them to officially be adopted. But as of right now, FEMA is regulating us by the use of the new maps. So as people are coming in now, we're telling them you need to meet this new standard. You absolutely have to. None of this changes the fact that we have a 3 foot freeboard requirement on top of FEMA's determined base flood elevation. Just added measure of safety, and it helps with all our folks through our community rating system, or CRS, where everyone in the county with flood insurance gets a better price on their flood insurance because we're held to a higher standard. I've got Mr. Lemos here from Island Authority if y'all want to ask about those. And I got Ms. Hampton here from Building Inspections if y'all want to talk about the building code.
All right, board, if we got any questions, we can
There was
take a stab
one
at it.
I had actually, and it comes back to I think it's yeah, it's on, should be. In this, what is it, like page 50? Why was substantial damage and substantial improvement deleted out in the draft ordinance?
Yeah.
Yeah,
if
so-
y'all wanna-
I don't know. I mean, I don't. It's in the definitions. That's what I'm saying.
Yeah, good morning, board members.
Yeah.
Juan Limos with the Island Authority. So again, like Mr. Homer said, we all work together with the FEMA contractor. The intent is to make all these regulations mirror each other, not just in the state, but within our jurisdictions. So the building code and the land development code had different regulations and different definitions on them. So the intent this time was to get all those to mirror from the land development code to the Florida building code. So it looks like you're getting rid of some stuff, but it is going to be contained on one of the documents. Those substantial damage, substantial improvement regulations are not going away. They're just getting placed in one single document.
I thought that was just an interesting one in there that was just deleted. I figured that was something that we,
So-
especially in the definitions, one to be deleted out. So
Yeah, so when you actually, you're looking at chapter six, at Article 6 or chapter 6 of the definitions? Yeah, so if you actually look into the different codes, both for the county and for the Santa Rosa Island Authority, we have individual definitions on each one of those chapters, and the substantial improvements, substantial damage determinations, they both in there still. And they are different between the county and the island. Yeah, we just had them in too many places, and that sometimes creates confusion. It has a tendency to send people to look for stuff that they shouldn't be looking at and make interpretations where they're not supposed to be. So it was FEMA's determination, along with your staff here at the county and the Island Authority, that we need to centralize all those definitions on the definitions section. And then if we had to remove them from there, then we put them on the individual jurisdictions, so make sure that we can manage all the flow regulations as we should have been doing.
okay, I'm good.
All right. Any further questions?
No question.
No. All right.
So 2, you got to vote on the 2.
Yeah, can we
And the
take
other
both of those in one motion, if the board so wishes?
Motion to approve?
Yes, no issues.
Okay, motion to approve, 6C and D. correct?
Yep.
Yep, all right, do we have a second on that motion?
Second.
On the actual agenda, it's item 5.3 and 5.4.
Yes.
Thank you. I got you. All right. Perfect. Stand corrected on that one. My apologies. So we do have a motion and a second. Any discussion? If not, all those in favor, please signify by raising your right hand. All those opposed? All right, those two items pass. We do have two other items today that do not require a vote, but more of a discussion item. So this is ordinance amending the Escambia County Code of Ordinances, Part 1, Chapter 14, Buildings and Building Regulations, and then also an ordinance amending the County Code of Ordinance, Part 1, Chapter 14, Buildings and Building Regulations.
Those are the Florida Building Code items.
Yep. So, no action required.
Okay.
And that's that.
Oh, those were, okay, I got you. My bad. All right, we have nothing else then, and I did not have anyone sign up for public forum. Anything from staff, attorney's office?
The next board meeting will be on June 3rd, and we have one rezoning case.
All right. If there's nothing else, we'll stand adjourned. See y'all next month.